Okay, welcome EFLC. It looks like you've just joined and your audio is good. So we're going to go ahead and start. We're just waiting for that connection to solidify there. I'm going to jump into our backgrounds here in just a second, but I wanted to make a quick disclaimer. We here at Worksana, we work with labor defense attorneys, but we are not lawyers. And I need to make that clear because there are 17 wage orders in the state of California, and depending on what your business or industry is, you will be governed by one of them. And we are not familiar with all of them, although most of the law is the same in all of them, but there are some differences between them. Furthermore, laws are changing every 6 to 12 months, and we don't stay up on them. So any of the HR policies that we discuss or you decide to implement, we highly encourage you to have it reviewed by your counsel based on the consistent changes that are occurring in the California Labor Code. So that's my disclaimer. I would recommend that everybody does an HR audit once a year. It might cost you $1,000 or $2, but it's probably the best insurance policy that you're ever going to buy. If anybody, if you haven't been sued yet, it's not when, it's if, or that's not if, it's when, I should say. I got that mixed up. So I want to start this off by saying something to all of us in California as business owners. We know that we don't intentionally take advantage of our employees, because if you did, you probably wouldn't be in business for longer than 5 minutes. But John Light, one of our attorneys, he said this, and I'll probably repeat it again throughout the presentation because it's pertinent. He said, "It's not that you did anything wrong. It's just that you did not do everything right." And PAGA is designed to make sure that if you fail somewhere, some of these trial attorneys, and with the help of the state of California, will be able to open you up to a huge amount of money to your organization, a big liability to you. So in terms of our backgrounds, quick dive here. Dave, he's our CEO. He's in Modesto today, setting up a client out there. He's with his son, Dylan, who works with us on customer service. I'm technically the CFO, but I wear lots of different hats. And Zach is our chief product officer, and he's the person responsible for making our software a great user experience and taking feedback from our clients for future roadmap development projects. Now, while we're not attorneys, Dave and I have owned a commercial janitorial business in Morro Bay since 1999. And unfortunately, our expertise in PAGA is because we have been through one of these lawsuits with our janitorial company. So I'm going to be sharing some firsthand knowledge as well as some good strategies in this presentation. The format for this, we're going to go, what is, a PAGA suit, how it can happen to you, how costly can it be, what measures can you take to sort of protect yourselves. I've got a couple of links to some industry resources. Then I'll open up to a general question and answer section. If anybody would like to text a question to Zach on the chat, go right ahead. He'll collect all those questions. And Zach, if something really pertinent jumps out at you while I'm in the middle of a slide, feel free to interrupt me, and we can address it then as well. So I guess I'll go ahead and begin the slideshow here. So the first slide, which isn't responding, is the target. And so as a California business owner, you are always a target. Again, it's not that you did anything wrong. It's that you didn't do everything 100% right. There's a complete industry in the state of California with trial attorneys that do nothing but look for infractions in the wage code to be able to pin something on you and create a situation where they can rope you into some form of class. So I wanted to speak a little bit about class action because PAGA is a class action. There's standard class action, and then there's the PAGA class action. And PAGA is a class, but it is a different species of class. If there's one thing I could tell you, if you haven't done it yet for your business, I would immediately consult your counsel and talk about arbitration agreements, because arbitration agreements are able to sort of mitigate the effect of the class. And they do that by sort of buffering each individual employee such that they've got to go through an arbitration process prior to be putting into a class. And that's oftentimes a big enough road bump for the litigators to not want to do that particular class action suit. However, the PAGA is completely different. So a little bit about PAGA. So PAGA was passed in 2004, it's Private Attorney General's Act, and basically it deputizes California state trial attorneys to work on the state's behalf with regard to wage and hour infractions as part of the labor code. This circumvents those arbitration agreements I was talking about because the state of California is not subject to arbitration. Therefore, if the state of California is deputizing an attorney to fight on their behalf, they don't have to honor the arbitration agreements. Therefore, your arbitration agreements, in the case of a PAGA suit, they pretty much go up in smoke, and they don't do you they don't provide any defense to your organization, but they do to standard class action. So I absolutely, like I said before, it's a very inexpensive insurance policy to embrace arbitration agreement policy. So in PAGA, the audit goes back 12 months from the date of filing of the PAGA claim, and then it moves forward until the claim is resolved. So while a class action typically can go back 4 years, just a standard class action, PAGA only goes back 12 months. However, that's misleading, because if your case drags on for 4 years, it could be 4 years if you haven't addressed the PAGA issues. Hopefully, if you ever get a PAGA notice, first thing that you want to do is you want to go address every single issue that they're going to bring up in the PAGA notification that you get from them. And they're going to throw everything in the kitchen sink in there. There's going to be 15 things that you're doing right and one that you might be doing wrong. And you need to go back to every single point that they're, alleging in the suit, and make sure that you're addressing everything, because they're going to be able to come back and subpoena records to try and prove or disprove any of the garbage they're probably trying to throw at you. And they literally, these are form letters, they're boilerplate kitchen sink type stuff. And you're just going to be asking yourself the question, where did they come up with that stuff? And it's only because if they throw it all in there, it gives them a better opportunity to nab you on something. So I wanted to let everybody know there are on average 200 PAGA lawsuits filed in the state of California every single week. So I did want to share some other information. And unfortunately, I messed up my screen share, so can everybody see this particular? Zach, can you see this one? The Private Attorney General Act?
Yeah, you're good, Trev.
Okay. So anyways, this gives you a breakdown. This came from Cal Chamber. We got this last week, and it only goes to 2018. But as you can see, right around 13 and 14, PAGA claims in the state of California just started accelerating. And that's mostly because of those arbitration agreements. So what would happen is these attorneys, typically these larger trial lawyer firms, they were getting really good at nabbing businesses on the class action, but the arbitration agreements began to make it more challenging, and they couldn't get as much meat on the bone. So then they started flipping a lot of these claims into PAGA, and now these numbers have accelerated in 1920, and I'm sure 21 is not going to be any different than that. Let's see. Back to this. So I'm just kind of going through my notes here for the next slide. I'm going to give you an example of some ideas that are going to create a PAGA violation, because it's all related to the employee's pay, their paycheck, the time of the payroll cycle. One of the things, unfortunately, in agriculture, a lot of agriculture companies have to pay every week, and that's bad for PAGA, because for PAGA, they go after pay periods. So if you paid somebody once a month, you'd have 12 PAGA periods which you could be on the hook for, a couple $100 per PAGA period, which is a pay period. But in agriculture, because you're paying somebody every week, you potentially could be on the hook for 52 PAGA periods in a year. So pay attention to your payroll cycles when you're calculating PAGA fines. So exposure, improperly calculated overtime. You've got to stay on top of that very, very astutely. In California, again, agriculture is changing. We're going all the way down to, they want to get agriculture down to 8. But every year, depending on the size of the organization, it's going to change. And if you're not paying attention and you are paying at the wrong rate, they're going to use that as a PAGA violation. You can have incorrect or missing accrual balances for sick time on the paycheck stub. That will initiate a PAGA violation. Improper documentation on the pay stubs. So for instance, if your company is called Always Clean, but you write Always Clean Inc. on the paycheck stub, that potentially can be a PAGA violation. The real easy ones for them to go after are the failure to adhere to document meal break compliance and failure to pay premiums for Mr. Tardy meal breaks. So it's not just enough that you have one of these meal breaks. It's if you fail to pay them, believe it or not, that could be 2 different PAGA fines. There's quite a lot of discussion about stacking fines. So if you had all of these fines in one pay period, the argument from the lawyer trying to sue you would be that this would be a $200 fine per pay period. This would be a $200 fine per pay period. This would be a 200, this would be 200 and so forth. And that would add up to $800 per pay period per employee if you had all of those violations in there. Now, the reality is the judge would have the final say. And so few of these cases have actually gone to trial that there's a lot of law yet to be discovered in terms of how stacking is adhered to. But suffice it to say that the judge in himself, in his or herself, would have the ability to make that call. And in the worst case scenario, they would stack it, and all of these could be, $800 per paycheck instead of 200 since you blew one of them. That's a little gray area. So I want to give you a hypothetical example. This is Dave's dairy farm. He's got 20 employees, former employee. For whatever reason, they can be disgruntled. They've heard an ad on the radio. Doesn't make any difference. As soon as that employee goes to a legal law firm and they want to subpoena these payroll records, you're pretty much going to get opened up, and they can come in and ask for just about anything. So in this particular example, Dave would encourage his employees to take their meal breaks, but sometimes they would skip them or take them late. That means it's Dave's dairy's fault that they did that, which is really, really hard thing to manage. And I can get more into that in a little bit. So roughly 50% of the time, the employees decided they did not want to take it, or they decided to take it late, and that's all Dave's fault. And so now Dave suddenly has 50% violations. So the remedy for the violation is 1 hour of regular time. So whatever that employee would make per hour, if they were minimum wage, it'd be 14. If you paid them 20, it'd be 20, whatever their rate of wage is, that is a meal premium penalty. So in this case, it was $15 times the 20 employees, times their working days, times 50% of the time. And that $37.50, you could argue that maybe you could pay that to your employees, but then the state of California comes in and they decided that, no, we're going to fine you on top of whatever you didn't pay in terms of penalty for not paying the meal period. Now you have a PAGA violation. So we're going to get you for $200 per paycheck times 20 employees times 225 paychecks times about $25,000 in legal fees. So this is just all the correspondence is taking place in the beginning stages of a PAGA. And I don't think I set it up here, but it's like a 1 to 4 year journey. We just went through a PAGA case and it was 3.5 years. So this is just kind of getting your feet around what that liability might look like to you. But when you actually dive in and go a little bit deeper, you realize that this law is set to the employee's advantage and it's also set to the attorney's advantage, the opposing counsel's attorney advantage. Because if they find one thing, if you go to court and they find one thing, you are on the hook for all of opposing counsel's court fees. And what's really frustrating here, I would imagine if a attorney was hired by the state of California, actually worked as an employee of the state of California, maybe on a good day, their state of California is paying their attorneys $150 an hour. But if you find one of these PAGA guys out of LA or San Diego, well, they get between $500 and $600 an hour, $700 an hour. Who knows what they are? So their fees add up really quick, and I can guarantee you they're going to inflate them wherever they can. So if you go to court, in addition to that 25,000, you're going to probably pay about 80 grand between all the depositions, all the court extensions, bringing your attorneys into court. Actually, if you had the trial, so you would say, oh, there's $80,000. And here's what's the truly unfair thing. So if you win, you cannot recover any of your attorney's fees. That is in stone, the way that the PAGA statute's written. There's nothing that you can do. So you're kind of left at the mercy of settlement, because you're going to pay this no matter what. If they find the violation, you're probably going to be paying this. So what they try and do is they try and come in with a settlement somewhere between this plus this, just under, and that's where they're going to try and probably come out and negotiate to settle. And there's nothing you can do about it at that point. So if you go to if you settle out of court, you're probably going to find yourself with another 30 grand in fees. Mediation in and of itself is 10 grand. Just went through that. I know firsthand that was $10,000. And then the mediator is going to settle the case for whatever they're going to settle for. One of the major differences I forgot to highlight between PAGA and class action is because the state of California is deputizing these guys, the state of California gets a cut. And so the cut here is 75%. So let's just say in this example, it was $100,000 settlement. After the attorney gets their cut first. So let's say the attorney, typically 30 to 35%, takes 30 grand out of this. So then you're left with 70,000. And of that 70,000, the state of California takes 75% straight off the top. And then there's a class manager that comes in and determines which employees may or may not have been eligible during the pay period of time. That guy is going to get $10,000 or $15,000. And so the sad thing here for the employee that thinks that they've just, sued their boss and we're going to get a ton of money, is that it really gets diluted in PAGA very, very, very quickly after the state takes their $75,000. They also award the lead plaintiff, I think, can get a bonus of maybe $5,000 up front, and then everybody else gets their small amount of money distributed, whatever that amount is, based upon how many pay periods they may have been eligible for that. But that all needs to be audited. So the other part that's not pleasant in this situation is you're constantly producing documents. You're running into your office, you're photocopying, you're sending them over to your attorney. They are, corresponding with you. I learned this early on. Don't ever say thank you to an attorney, because they'll send an email back to you and say thank you, and that'll cost you $45. So just try and make everything concise if you to deal with your attorneys. So I wanted to now jump into meal break, because this is probably the hardest one to manage, and it's the easiest one for the attorneys to find. So state of California stipulates that meals must start prior to the 5th hour of work. It's a violation if the meal is started after the clock hits the 5-hour mark or is not taken at all. There are some, again, I mentioned there were 17 wage orders. In certain cases, there are meal break waivers that are eligible for the 6th hour. So if you got a workforce that usually doesn't work more than 6 hours, this was the famous Brinker case, which was the Olive Gardens and the Chili's of the world. They argued that their employees were only going to work 6 hours, and there was a standing waiver that would allow sort of that extra 1 hour buffer. That was only applicable to that 6 hours. So here's where they would get caught up. If the employee worked 6 hours and 10 minutes, they were supposed to have taken their 30-minute uninterrupted meal break prior to the 5th hour. So they were already in the penalty box. So it's, unless you have total control on a 6-hour work shift, those particular blanket waivers can be or cannot be of value to your organization. If they do not take it for at least 30 minutes, so if they take a 29-minute meal break, it is considered a violation. So keep that in mind. And it needs to be uninterrupted. It has to be the technical term, I believe, is duty-free and uninterrupted, meaning employee can't be, taking a phone call from somebody at the business. They can't be monitoring something. They have to be completely duty-free. Otherwise, violation. So then they're owed the 1 hour of extra hour pay. I mean, the good thing here is this doesn't go towards overtime. So it's just a straight hour. It doesn't count if they had worked 40 hours and got a meal break premium violation. You wouldn't owe them the extra hour and a half of OT pay. It would just be a straight 1 hour of regular pay. You are responsible for having a clear policy outlining these expectations and a way to enforce them. And you must document the timelines and or premiums you've paid every single worker for every single pay period. So what they look for when they go on their fishing expedition is they look for those time card records, and they're looking basically to see if those violations occur, because it's really, really easy for them to see the punch in, start of day, count the time until punch out for meal break, punch in for meal break, and then end of day. It's really easy for them to run. I mean, they've got, Excel spreadsheets that they just crunch these numbers, and they can figure out what your violation rate is very, very quickly. So that's something to be mindful of, is that that's where they're going to go. And once they have one thing, they're like a shark swimming in the water with blood. They'll just keep coming after you for more and more and more, because they want to get as much as they possibly can. So let me see. So that takes us sort of to so how can Worksana, or how can any payroll or time and attendance company help you? And in that regard, we are sort of the documentation experts. So we can help you through that documentation and help you be proactive as much as you can. But I would preface this, and this is where discussing with your counsel the policies that you have in place. We can't help you on the ground with managing your employees. There's nothing. All we can do is show you where the mistakes are being made, who's making the most number of mistakes. But at the end of the day, it's going to take a fully embraced, committed, managed policy to stay ahead of this thing, because it's happening every single day for every single employee. So the sheer volume of potential violations is unbelievable. When we have a flagging system within Worksana, and that flagging system, I don't turn it on for clients when we first start engaging with clients, because just getting people to punch in and punch out and manage the system has its own set of pitfalls that need to be worked through, and employees need to get comfortable using, whether it's their phones or the tablets or however they're punching into the time cards. That needs to get sorted out first, and then I come back usually and we'll tell a client, okay, do you want us to turn on the meal break management flagging for you? So do you want to go ahead and use our system for one of the key things that it was designed to do? And they'll say, yeah, sure, let's go ahead and do it. And we'll turn it on, and the flagging system is orange, and almost every single time without fail, those time cards just all light up. I'm just scratching your head going, you have, so many customers I've talked to, obviously, you have a serious problem within your organization of people that are not abiding by the meal break policy. And it could be for a multitude of reasons, but the primary reason is that the policy is not clear, and the policy is not part of the culture, and the policy is not enforced. Any one of those three things is missing, and the whole policy falls apart. So the policy in and of itself needs to be vetted through your attorney. And because an individual employee can waive a specific meal break for that day, but if they do that specific meal break needs to be documented in writing that they waived it. And if you can imagine, with dozens of employees or even hundreds of employees, you give your employees the opportunity to do that, then somebody's going to have to run around and collect all of these waivers every single day. And that's just, it's physically impossible to do that. So the best course of action as a company, we have found, is to create a policy that your employees are mandated to take these breaks. That way, if they don't take them, then it's the employee's fault and it's not your fault. So that's a pretty cultural thing there. For the enforcement. And that takes a lot of pressure off of you as an employer, tracking everybody down, trying to find these waivers. So the first piece of the puzzle is to get that policy in place, make sure it's vetted by your counsel, and then you need to begin to enforce that policy. And unfortunately, a policy or a program or a system or any of those things that you implement within your organization, if it's not part of the culture and it's not followed up upon, then it will disintegrate and it'll mean nothing. It would be a big waste of time. So that's the commitment to doing something like that. And because this is a proactive policy, you don't realize the benefit of it until it's way, way, way too late. Like I said, they'll go back, in the class, they'll go back 4, but if you had the arbitration agreement and they go for the PAGA, they'll go back 1 year. If you hadn't been doing it for that 1 year, then you've got a year's worth of liability sitting on your shoulders. So the commitment to it is critical. And that's not something that we at Worksana, we can tell you about it. We've seen it. We've experienced it. We know it, but we can't do it for any of our customers' businesses, unfortunately. So back to what we can do, what our software can do is we have a meal break alert function. We can document it and we can give you the best advice that we know. And we've got a network of labor defense attorneys and HR companies that can help solve problems and answer questions. So I'm going to show you some of the functionality in the software. So number one, if they're on the mobile device, I should preface that because it doesn't work on the kiosk because not I'll sit next to the kiosk or the tablet or the desktop or whatever. But if they're on the mobile device, we can push out a meal break notification. This is pretty powerful because then you can argue as an employer that you are encouraging your employee to take that break. That's a big step in the right direction of identifying the fact that you understand the meal break laws as opposed to not knowing them. Because if they think you don't know them, they're going to come after you much harder. So we configure that setting anytime you would like that, and that pops up on the screen as a meal break notification. The secondary thing, and it's not in the slideshow, I think somehow we left it out, but we can also freeze them out from coming back, and this would be on the kiosk or the mobile app. We could freeze them out for coming back for the 30 minutes that you need to document inside that time card that they took a 30-minute uninterrupted lunch. If they want to argue that their lunch was interrupted, there's a way within our software where they can actually send back a correction request to the office and say, actually, my meal break or my rest break was interrupted, and therefore I should be paid the meal premium. And we give them the opportunity to do that. Now, you as an employer can then investigate to see if that was actually the case and pay them or not pay them, depending on what your findings are. So this is the alert system. The secondary functionality here is the flagging system. So right here in our software, like I said before, we'll flag that orange. It'll identify whether it's a missing meal period or a delayed meal period. And then from there, typically you're going to need to address it with the employee. And what we found is we use a system where we contact the employee and we say to them, what happened here? And they will then tell us what happened. They can do it in the form of a correction request on the app. They can say, hey, on yesterday, I forgot to punch out for lunch. It should have been between this time and this time. And that's the employee writing that information. That's either on the mobile app or on the kiosk. They send us that information. Now we have a documented record of that information. Now we can change the time card. It's no longer flagged. They actually took it. Or the employee can say something to the effect of, actually, due to the constraints of the job, didn't have time to take the meal break. And then you as an employer can pay the premium. And that's a good thing too, because when these attorneys come in and they try and audit your records, if you do have several meal break premiums that have been paid, then that shows that you are managing the system and you're taking responsibility for it. It's nothing's worse than having them come in and you've never paid a single meal break premium. That pretty much guarantees that they're going to have a stronger case in court, or at least a stronger case to the settlement manager that you're not adhering to the fine laws of the state of California, and therefore you're on the hook for more money. So the flagging system lets you know what that is. And then the reporting on the flagging system lets you know who is creating these problems for you. So I said, one of the cornerstones here is to have a policy that mandates that your employees take these meal breaks. And if they don't, then there's some course of corrective action that can be taken with the employee. Well, this is a great way to see who the gross offenders are. And in our own organization, I oftentimes will say things to our employees such that, if a specific employee is struggling with something, let's say it's a meal break issue, I can say to them, I say, in this case, Jordan, you've got 2 meal break violations, but Trevor never has any. Why can he do the job, but you can't? And oftentimes that's all you've got to say to these guys. As long as they know that you're watching, they'll stop testing you. But that goes back to managing your policies. If they think for a second that you're not watching, they're going to revert back to what they've always done, unless you have a cultural change within your organization. So one of the things that's really interesting, if you come to work for a place that the culture is that already exists within that organization, then that brand new employee never knows any different. So if you try and implement a system or a cultural change in your organization that's never been there before, you oftentimes are going to get a ton of pushback because everybody's going to go, well, why do we have to do it this way? It's a very interesting dynamic, but people don't like change. And yet people that are brand new to our organization don't know any different. So it's a psychological thing, but there's a lot of different ways that we've learned over the years to sort of get everybody on board and do the right thing. Anyway, so we do the documentation format here. And then the last thing are the proactive measures that we've got in place. So we've got the ability to add that meal break premium. So when you see it and it's a legitimate issue and they legitimately didn't get that break because business conditions did not warrant it, or they were interrupted because business conditions warranted that, and you owe them that, please make sure you pay them, because that will make you have a stronger case in court. The other one is the compliance attestation. So after every single shift, at the end of their shift prior to the punch out, the employee has 2 choices. They can either submit a correction request or they can agree to this attestation. Again, your counsel have to write your own attestation because they're different for every wage order. But basically they're saying to the effect that I did everything right. I had taken my meal breaks. I was provided my 10-minute rest breaks. There was no injury on the job. Whatever you want to put in the compliance, make sure it's in Spanish if your employees don't speak, if your employees speak Spanish and not English. And then they will then have to submit that. Otherwise, they'll go back and submit a correction request. So we always give the employee the opportunity to submit a rebuttal and say that this is not true. And so if we say that this is not true, then you're going to expect a correction request in the software, and then their correction request then can be actioned upon by a supervisor or manager. So in summary, we've got the alerts, we've got the documentation and the flagging, and we've got the ability to pay them, document that you're paying meal break premiums, and that they can attest to this. And you can even print this form out and they can sign it. That's another layer. Again, our defense attorney has said, if you want to keep your pants up, wear a belt and suspenders. So have them attest every day. And if you're really concerned about it, have them sign it too. So we can print out a signature document with all the same information on their shifts as well. So, I was just going to go into some references. So in the Valley, I said, we're doing a lot of work between Fresno and Bakersfield. There's a gentleman, Ken Hernandez. He does amazing work for HR. He is so hands-on. He will come to your facility. He will do the write-up for you. If there's a work comp issue, he will take the employee to a clinic. They all speak Spanish, obviously. And he's been doing this for 30 years, and he's just a really good hands-on HR company that specializes in agriculture and in work comp and wage and hour issues, and I should say disciplinary issues as well. Couple of the other resources. So I'd mentioned Light Gabler, John Light. We've done an immense amount of work with him. He's awesome. It's all he does is defense. And then Ian Weiland, he's out of Fresno. That's all he does is defense for firms. So there are others. I would encourage any business owner for this type of stuff to use a specialist, because there's a ton of attorneys you can look up in the phone book. I mean, some attorneys will defend a business owner and then turn around and sue a business owner. So there's plenty of generalists out there, but this case law for wage and hour type stuff is so vast. Highly encourage you get somebody that does that and only that. And these two firms I would recommend. Beyond that, we have partnered with a gentleman that's trying to change all this. So I think I referenced that earlier document here. This, and I can send this document to anybody. This is from the Cal Chamber. It gives a lot of information about what's happening in the state of California, what the legislator is trying to do, how things are changing. I mean, obviously, this PAGA situation is a plague, and business owners know it. But we unfortunately live in a state where the business owners are usually behind the employee when it comes to treating them fairly or justly. So the state tends to take the opinion that the business owner can handle it and the employee needs the state's assistance. And so that makes legislation to diffuse some of this PAGA stuff challenging. However, this gentleman right here, Tom Manzo, has created CABIA, which is California Business Industrial Alliance organization. He is the primary advocate to overturn or change PAGA, and I highly encourage you to follow him or even support him monetarily. He's been putting some TV commercials together, some radio commercials together, and he's got the ear of lawyers who are trying to change this law and ease up on us. I mean, one day the pendulum's hopefully going to swing back towards the business owners, but it's going to take a momentous effort. So Tom's the guy who's leading the charge to do that as best he can. Okay, so I think I've said my piece here, Zach. Do we? Oops. You still there?
Yeah, Trev, I'm here. I think we were just going to open it up for questions. If anybody here wanted to ask anything, feel free to unmute and just fire off.
So just FYI, I think our system's automatically muted everybody. So if you did have a question you wanted to ask, hit the unmute button and we'd be happy to ask it or answer it. Sorry.
Okay. Well, Trev, the one thing I think that we didn't get into, I mean, we covered the meal breaks pretty extensively, but I know I fielded a lot of questions lately, just in general about documenting press breaks potentially becoming a thing, and I know that we had covered that with John not that long ago, so might sound off on that for just a couple seconds as well.
I will. So yeah, great point. Rest breaks and meal breaks are handled completely differently. The meal break, at least under the wage order for our janitorial company during our last PAGA suit, the meal breaks were inline edits within the time cards, and the rest breaks have to be offered to the employees every 4 hours or a major fraction thereof. And what that means, and the rest breaks have to be paid, the meal breaks do not have to be paid. The rest breaks, you need to have a policy that encourages your employees so they understand that those rest breaks are available to them. That's not one that you need a document from the employee to sign off every single time they decide not to take a rest break, but the employee does need to acknowledge that as a company, you are encouraging them to take that rest break every 4 hours or major fraction thereof. And of those rest breaks, they also need to know that if they don't get that for whatever reason, they definitely need to be contacting the office, and they sign that. So one of the things John Lightfoot did for us was he created the Employee Bill of Rights, and pretty much all that verbiage about their ability to have that rest break is in that verbiage, and they sign for that document. And then they're also made aware that if they've got a supervisor or a coworker who's encouraging them not to take that break for whatever reason, sometimes employees want to finish faster, but one employee may want to take that rest break, then they're encouraged to speak up, and they understand that there is a channel of communication back to the office that allows them to voice that concern. Because typically with rest breaks, what we've seen is that it's going to be one employee really wanted that rest break, but was sort of peer pressured by another employee maybe not to take it. In the case of manufacturing or a factory where they can blow a whistle and everybody can take those breaks, it's easy to control. But if you're in agriculture, or if you're in a service contractor out in the field, they're much more difficult to manage from a policy on a daily standpoint. So you definitely have to have the documentation, the read and sign, so the employees understand what their rights are and how to get that information. Yeah, good question, Zach. Okay. So if you have any questions, have any comments? Zach?
Yeah, I think we could probably call it a wrap. So yeah, just wanted to thank everybody again for hanging out with us. And again, if you want to talk more offline, or privately after this, just drop an email to Trevor or myself. We'll also send over this document that Trevor displayed as well. So again, thank you guys so much for hanging out with us. And I'm sure I'll be talking to probably, it looks like, most everybody in this room soon. Anyway, so yeah, just cheers.
Thanks, everybody.